Hello, and welcome to this episode of the Maryland Risk Management Education Podcast. My name is Paul Geringer. I'm the Extension Legal Specialist here in the Department of Ag and Resource Economics at the University of Maryland. And today I want to continue on with the theme, that started with the last one around things you can do in the new year to help benefit you and your operation. We can continue on with that and talk about, why you should start thinking about estate planning, succession planning, especially if you have an ongoing farm business that you hope will continue on to the next generation. And there are people there willing to continue on working it into the next generation. So with this, many of you may already have these estate plans. You may have succession plans, and one of the biggest issues that can come up with those is how do we handle issues related to both on-farm and off-farm heirs? If most of the majority of the properties tied up in the farm, how do we handle that, that distribution of assets between the two sets there? Now, if you have these, are you communicating that decision? If you don't have one, have you sat down and thought about how you're going to communicate this decision process and work with the heirs to set this up? If we look back a few years ago, there's an interesting case out in North Dakota. It's a state of Feldman versus Evans, and it sort of handles this issue of how do we handle these issues that come up between, on-farm and off-farm heirs. In that case, the Supreme Court of North Dakota agreed with testimony showing that the father gifted all the farm equipment to the on-farm heir, his son, equipment which was not a part of the off-farm heir shares of the estate. We'll talk about why this was an issue here in a minute. The on-farm heir was also entitled to the wheat crop growing on his inherited farmland. The on-farm heirs were only entitled to proceeds from the wheat crop harvested at the time of their dad's death. The takeaway from the case is, and this is the thing that we often talk about at farm succession workshops and, workshops, webinars, anytime we do this, is families should discuss these issues to make sure that everyone is on the same page. So heirs understand how property will be treated at death or when it is gifted to another heir to reduce tensions and avoid litigation. So let's get into the facts of the case. In Feldman, the father had one son who appears from the case to be on the farm and two daughters who appear to be off farm. The father and son agreed in 2004 that the son would farm dad's land using dad's equipment, with dad keeping the proceeds. In 2009, one of the daughters overheard a conversation with dad saying, "The equipment is all son's now." Father dies in 2011 with a valid will, leaving farmland to son and personal property to daughters. At the time of his death, the majority of the wheat crop was unharvested. So what are the issues before the court? The court really had to deal with two issues. Was he to the son? That's the first issue. Issue two, did the proceeds from the wheat crop belong to father's estate and not the son? Or did they just belong to the son? The court's decision looks at it this way. A valid intra vivas gift or a gift made during one's lifetime requires an intent to give property to the other party, actual or constructive delivery of the gift, and acceptance of the gift by the other party. Without the testimony of the daughter regarding the phone conversation, the court would have considered the farm equipment to have been considered personal property that the daughters potentially would have been entitled to if the court determined that the property had not been gifted to the son. So we think about this, there's equipment there, they get the personal property. This could be a high-end issue in the settling the estate. But it appears from the testimony, that one of the daughters gave that it was a gift. In looking at this case, the dad's will mentioned a list of property considered personal, but the list was missing. Also missing were tax documents, which might have demonstrated gifting of the farm equipment to the son. The only evidence of the gift was daughter's testimony of the overheard phone conversation, where her dad stated that the farm equipment was now the son's property. The North Dakota Supreme Court considered this enough evidence to support the claim. The farmland the farm equipment was the gift to the son and upheld the trial court's ruling. Typically, unharvested crops go with the real property. Here, the dad had an arrangement with the son that stated son did the work and dad got the proceeds of the crop. The lower court ruled that the standing wheat crop passed to the son as a part of the real estate. The harvested proceeds passed to the two daughters. The North Dakota Supreme Court agreed with this ruling and affirmed the lower court's decision. So why do we care about this? This case highlights a lot of things that can happen when parties do not clearly state what's happening to personal property when one party passes. Here, Dad had an estate plan, but made changes. He gave equipment to the son and did not let the other heirs know. We have a communication problem there. The change impacted the daughter's share of the estate, and you can see why they might fight over it. That daughter might have felt that brother was getting everything from dad and she was not being traded fairly. This case really does highlight why communication is important in this process, especially when we start making revisions to the plan. The other thing this case highlights really, really well is why you should keep your documents together in areas where everybody knows where they're at. If we go back and look at this, there were tax documents missing that could have demonstrated it was a gift. Dad's tax documents were not in a spot that were easily accessible and people knew where they were at. There was a list of personal property that was included in the will. No one could find the list. What happened to the list? Where did that list go? These are things we could put up. We all lose documents over time. We need to figure out a spot, whether it's a safety deposit box. Other people tell me they have safes in their house and heirs know how to get into this. These are things we need to start thinking about and taking into consideration as we're developing these estate plans, and then making sure that we're maintaining them over time so people know how to access them. Everybody knows where they're at, and these issues do not arise. So thank you again for listening. If you have any questions, you can email me at lgoering@umd.edu, or you can tweet me at aglawpaul or send me a message on Instagram at the same handle. If you have topics you'd like to be considered on the podcast, please let me know. Thank you again for listening and enjoy the rest of your day.